to Station 3, the Judicial Branch. I'm going to mess up saying that this whole entire time. But welcome to this station. What you guys are going to do here is you're going to watch a video of me talking about the Judicial Branch. But before you watch the video, or you're actually watching it now, but before you really get into it, I want you guys to take a pre-test about the Judicial Branch. I'm not grading it. I just want to see what you guys know before going into it. Then after, there's a little post-test you need to take, and I kind of want to compare the scores to see how much learning is taking place. So take the pre-test now, watch the video, then take the post-test. I think we got that. Awesome. Have a good day. Enjoy this station. The judicial branch of government was established in Article 3 of the Constitution with the creation of the Supreme Court. This article said, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at times receive for their services a compensation which shall not be diminished during their continuance in office." The Supreme Court is the highest court in the land. It's the top gun. It's at the very, very top. And it's empowered with all these judiciary powers in government. There are a lot of federal courts, a lot of state courts everywhere else, but they were not created by the Constitution. Only the Supreme Court was. Congress thought, these little courts, these federal courts were necessary for using the powers in the Constitution. Maybe decide murder trials, decide different kind of trials. But that's why Congress put those ones on. But the Supreme Court was the only one that was actually in the constitutions. The Supreme Court decides a number of things, such as arguments about meanings of laws, how they are applied, whether they break a rule within the Constitution. If the Supreme Court decides if a law or government action violates the Constitution, it enables, it can override it. And it can override federal and state laws. And if something's unconstitutional, they say, hey, you can't do this anymore. This is no longer a law. And this is called judiciary review. This came about a long time ago, and we'll get to that in a minute. Since the Supreme Court stands as the ultimate authority in constitutional interpretation, its decision can only be changed by a constitutional amendment, which is a change to the Constitution. Something different from the Articles, because we need to get 13 out of 13 states to agree. Now we can amend the Constitution a different way. The Supreme Court's kind of like referees in the football game. They settle disputes among two sides. Their decision is final, and they are the ultimate authority figure here. And they reflect on a lot of important issues in the country at the time. For example, in 1954, the Supreme Court ruled that a racial segregation in public schools was wrong. And this was in a decision called the Brown versus Board of Education decision. You'll probably talk about this later in high school probably. But judiciary review actually came about in the Mayberry versus Madison case. You see, what happened then was John Adams was president, and he signs an appointment on his last day as being president. He appoints William Mayberry as a judge. Thomas Jefferson was taking over office the next day, and James Madison, the new Secretary of State, was supposed to present Mayberry with his new position. However, Madison didn't. So Mayberry sued, and he appealed to the Supreme Court to get Madison to award him that position. The Supreme Court refuses. And why? Why did they refuse? Because a section of the Judiciary Act of 1789, which set up the federal court system in the first place, it was unconstitutional and voided. So this was the first time in history the Supreme Court overturned an act of Congress. This was checks and balances in action, and we'll talk about checks and balances later on, probably later this week. The Supreme Court is made up of justices. There's 9 of them. One of these is the Chief Justice. They are appointed by the President, and they are approved by the Senate. Justices have their jobs for life. They have life terms. unless, of course, they resign, retire, or impeached for, robbing in a 7-Eleven or something. So they have their jobs for life. So take a stretch break right now. Tell your neighbors around you if, a life term limit is a good thing in society. You know, I want you guys share your opinions. Take a stretch break. So should you have your job for life? Are you accountable for all the decisions you make? That's what a lot of people ask about, the Supreme Court. We're not really going to get into that, but just, keep that in mind. Our life's terms great. They might be. There are actually no official, qualifications for justice in the Supreme Court, but all have been trained in the law. Many justices have served as members of Congress, governors, or even members of the president's cabinet. One president, William Howard Taft, was later approved, or later not approved, appointed Chief Justice of the Supreme Court. So that's pretty awesome. Most cases do not start in the Supreme Court. Many cases, they start in the lower courts, like a state or federal court. And if a case starts at the local level and the losing party does not think justice was served in this decision and they appeal it, they can bring it to a higher court. And if the higher court does not agree with, if the higher court agrees with the lower court, that party then may again be asked to take that thing to the Supreme Court. But only cases involving federal or constitutional law are really brought to the Supreme Court. Murder trials, those kind of things, not really Supreme Court material, but, constitutionality laws, they are brought to the Supreme Court. Actually, over the course of a year, around 7,500 cases are sent to the Supreme Court. And out of all these cases, only about 80 to 100 of them are actually heard by this court. Why, do you ask? Well, when a case arrives and heard by the Supreme Court, several things have to happen. First, justices get together to decide whether the case is worthy of being brought before the court. In other words, does this case really involve a federal constitutional law? Secondly, a Supreme Court ruling can affect the outcome of hundreds or even thousands of cases across the country. Therefore, a court tries to use its enormous power only using it on cases that concern and really concern itself with a pressing, constitutional issue. So that's the judicial branch in a nutshell. So go ahead, go complete your post test right now online on Google Docs, and we'll probably talk about this later on. Have a good day, guys.